Welcome to Plead the Facts, presented by KI Legal. On today's episode, KI Legal co-founder Michael Iakovou and senior associate Matthew Zwiren announced the establishment of KI Legal's Landlord-Tenant Litigation and Family Office Consulting Division.
Welcome back to Plead the Facts, everyone. I'm Mike from KI Legal, joined with my associate Matthew Zwiren. We're here to announce some really big news. We can't stop at KI Legal, hence the coffee. Q4 has been crazy, lots of deals closing, and only good news, thank God. And we want to share some of that good news with everybody here today. And that news is we are formally announcing the establishment of our Landlord-Tenant Division, a part of our overall strategy and foundation, we'll call it, to better represent our hospitality group clients and our family offices and private equity clients. Matt Zwiren, thanks for being here today. Before we get into it and exactly what that means for all of our clients, I'd like to just say on a macro, general level, this was a decision that we really thought of. It did take months and months of planning, and we have been taking cases for the better part of the last 2 months at this point. And now we are formally announcing for 2023 that we will be opening this up to more of the public and our clients. And the reason being was, everything that we do, it's for, again, the total circle of our clients. How can we better represent our clients from A to Z, kind of being a one-stop shop for those hospitality and real estate family office clients.
Definitely, Mike, and I think it dovetails really well with what KI Legal has as their core competencies, being litigation, being transactions. Landlord-tenant is almost the culmination of both of those divisions into one. We're dealing with real property assets on a regular basis. Our base knowledge of real estate, New York City real estate in particular, and the markets in which those assets trade and operate helps to inform our litigation strategies concerning the landlord-tenant aspects of the practice division here.
And what diversifies us from our competitors, again, we'll get into this a bit further on into the podcast, but I think the biggest thing to really take away from this is that L&T is an ancillary practice group to our core competency. It's not the only thing that we do. So why does that matter? It matters because where some firms would just kind of kick the can down the road in order to quote unquote generate fees, whatever it may be, I don't know what their rationale is, we like to get things resolved for our landlord clients because we're doing a million other things for our landlord clients, and we know at that given point in time we've been charged with that responsibility, and we take it very seriously. For us, we, like I said, it's the one-stop shop for our clients, and it's, in the PI context, as we say, hey, we don't need to settle this case, right? It's actually the converse with L&T. We have no problem getting something resolved because it helps the overall representation of our client and just to keep our business-focused clients keep going, and that's really the name of the game in New York City.
And I think something that you mentioned there is the overall ideology and the techniques that we bring to landlord-tenant litigation and practice are vastly different in my experience than many of the other large L&T focused only firms that operate within the New York City metro area, in the 5 boroughs specifically. Most of those firms, as you noted, are landlord-tenant litigation firms only. That's all that they do. That's the only way that they generate revenue is by handling those matters, and they don't see the bigger picture concerning some of the clients that they service as we're able to do here. So we go into our landlord-tenant litigation with a bit of a different way of thinking.
It's a mindset.
Yeah, exactly. It's a mindset. We don't want to adjourn a case out 5 and 6 times. We'd rather settle it that time that we're in court, get our clients a definitive result if we can possibly do so, and move on with that client to demonstrating to them, hey, we were able to resolve these L&T matters for you. Now we can go and look at that refinancing possibility. We can go and look at a sale or to purchase another asset that you would want to get into, because you have the ability to quickly resolve landlord-tenant cases, to generate cash flow, to generate revenue for that client, and to move on to the next. So I think it works perfectly.
Yeah. So let's move on to what our core offerings are going to be in the LNT space. Matt, let's just rattle them off. We don't really need to go into them. If you have questions, please feel free to DM us or reach out to me, and we'll break out more of what these core offerings mean.
So we offer we run the gamut in our offerings concerning our landlord-tenant litigation. We do commercial non-payment petitions, we do commercial holdovers, we also do residential non-payment petitions and residential holdovers. Those holdovers can range from a squatter who somehow made their way into a unit for more than 30 days, or it can be a super who has lived on the premises for several years, has had some sort of employment dispute with the owner of the property, and therefore that the apartment they get as part of their compensation for that work, we would be able to repossess that apartment.
On that note, we typically do have clients that have a variety of issues, again, across different practice areas, and to Matt's comment about a non-pay from a super, right? That's a very commonly filed matter or case in New York right now. So you'll have a labor and employment issue there, and you'll have some kind of landlord-tenant issue there, and we handle everything in-house, and we handle one in conjunction with the other. It's not like the departments aren't speaking to each other. We kind of do everything in tandem, which again, from a product offering perspective and a representation perspective, it is definitely where you want to be as a client.
I'm glad that you mentioned the employment aspects of it, because often once these holdovers are filed against a super, the first thing that they'll do is they'll find a plaintiff's employment attorney and attempt to find any sort of discriminatory suit, labor law suit, overtime suit that they can find, just to stick it back to that landlord and to be able to have a little bit of extra leverage in that negotiation, whether it's the amount of time that they want to be able to vacate or a payoff of some kind. So having that knowledge here is definitely something that sets us apart. I'll go into a little bit more of the in-depth landlord-tenant offerings that we have. We do landlord representation in HPD, that's housing preservation, cases that are initiated, whether it's by the actual HPD department itself, whether it's by a tenant claiming under the multiple dwelling laws, or any of the rent stabilization or administrative codes in the city of New York. And additionally, on top of that, we can also do representation in front of the numerous oath, that's the Office of Administrative Trial and Hearings boards that there are, whether it be ECB, DOB, or HPD, as we said previously. And also, just to mention, we also have a bankruptcy department in-house.
Yes, so 363 sales, lease renegotiations, and out-of-court and in-court workouts, asset protection, it all happens here at KI Legal. So again, to reiterate the initial point, this was probably the last cog of the wheel to better represent our clients, and we're excited, to offer it, but to do it in a methodical way that was well thought out. If you have more questions, or any questions for that matter, please feel free to reach out to us, and we'll be able to better tell you how we can potentially assist you.
And just to demonstrate how all of our practice divisions can really work together, if we are handling the landlord-tenant litigations for any particular building owner in New York City, if that building owner then wanted to go sell or refinance that property, we have all the intimate information that it would be necessary to speak to that lender or that potential purchaser to get them comfortable with the state of the landlord-tenant litigation ongoing in the building at that time. We can have an idea as to the amount of arrears that will be on the building when the sale takes place, and how collectible those are.
And explain that to lenders counsel to the extent that you're looking to potentially buy or acquire a building, right? Even if we're not representing you on, if there's nothing for us to represent you on the L&T matter, we understand these things, and getting a lender or lender's attorney comfortable with these issues is also something that we can do, because we understand exactly what the cases are and where they're going. That's it from us. It's been a great year. Please feel free to reach out to us, and we'll look forward to working with you in 2023. Thank you.